Minister.
Adam Searle.
Mr Assistant President, I lead for the New South Wales opposition in debate on the Residential Tenancies Amendment Social Housing Bill 2018. The opposition does not oppose the legislation. We do, however, have 3 amendments which have been lodged with the clerks for the consideration of the House, which addresses some of the concerns we have about the legislation in its current form. The bill proposes various amendments to the Residential Tenancies Act 2018 and the Housing Act 2001 to allow for a rental bond scheme to be applied retrospectively to existing tenancy agreements under certain conditions, and to provide for the termination of existing tenancy agreements in instances of fraud. The legislation before the House could exacerbate the incidence of homelessness if it's not implemented properly, Mr Assistant President. A number of concerns with the legislation have been raised, and some of them the opposition believes warrants further attention by the Minister. Some of those concerns are embodied in our amendments. There's no question that homelessness is on the rise in this state, as it is in many other jurisdictions. We could never be proud of the 37% increase in homelessness that was revealed in the last census data. The impact that this bill could have on some vulnerable tenants has not been made clear, and there will need to be some considerable amount of oversight and indeed a timely review of the legislation, similar to the review that was agreed to in relation to the antisocial behaviour legislation in 2015. It's critical that we do not, in seeking to do some good, create a situation that exacerbates homelessness or impacts unnecessarily on vulnerable tenants who may be third-party victims of the kind of behaviours we are seeking to address, and that is the substance of Labor's First Amendment. The introduction of this bill comes 3 years to the date of the introduction of the Residential Tenancies and Housing Legislation Amendment Public Housing Antisocial Behaviour Bill. The 3-year statutory review of the 2015 amendments are due to be shortly handed down by the Auditor-General, and I understand the government is expected to respond to those findings by November of this year. This bill forms part of a broader policy change within family and community services, which will see the introduction of bonds for tenants who have intentionally or negligently caused $500 or more worth of damage in a family and community services property. The opposition does not condone the type of behaviours that the legislation seeks to address. We do not condone any tenant willfully damaging their property in any manner. However, the broader policy does not actually require legislative change. There's nothing to stop FACS from charging new tenants a bond. All that is required is a policy change. It's understood that FACS is intending to introduce that during the course of the year in particular circumstances, and the aim of this legislation is to allow FACS to charge a bond to existing tenants who have instigated at least $500 worth of damage. As we understand it, those rental bond scheme guidelines are yet to be made public, but I do note the FACS Housing Ministerial Guidelines Rental Bonds 2018 that the Parliamentary Secretary has incorporated in his speech, or sought to be tabled in the Parliament. I thank the government for providing that to the opposition late this morning. We think it's good to have it disseminated, but one of the flaws in the bill, which we seek to address in an amendment, is of course deals with these guidelines. These guidelines are provided for on page 4 of the bill in proposed 156 capital D subsection 7, which says rental bond guidelines mean any guidelines approved by the Minister for the purposes of this section. The problem with that is it means that the Minister has an absolute fiat to provide guidelines, to change them, and no doubt a prudent Minister and a prudent government would disseminate them in public, but they don't have to, and there is no scrutiny by the Parliament of those guidelines, and so we will be proposing at the appropriate time in our Amendment 3 that the guidelines be implemented by way of regulations made under the legislation, so that this House, or indeed the other House, may appropriately scrutinise it, either through our Regulation Review Committee or through the deliberations of this House. We just think that is a safer and more appropriate institutional course of action. So it's good to have these guidelines available before this legislation is finalised, but it does come very much, Mr Assistant President, at the heel of the hunt. Although I've seen them, the opposition hasn't had the chance to consult with external stakeholders. We don't know whether they've got them. We haven't had the opportunity of determining whether the guidelines are fit for purpose. And so that is one of the reasons we think it shouldn't simply be an administrative action by the relevant minister, but it should be through a regulatory process. Concerns have been raised from within the sector that seeking a bond could potentially place pressure on specialist homelessness service providers, as vulnerable tenants may not be able to financially cope with the imposition of a bond. There are concerns that brokerage would potentially be utilised for the purposes of those tenants providing a bond. We would like the government to clarify and rule out that specialist homelessness services will be required to use brokerage in such a way, and in instances where a tenant is unable to provide a bond following a course of action that FACS might undertake, including a termination notice should the bond not be paid within 14 days of the notice being issued. As I understand it, the bill provides that the termination notice must state that there's an opportunity for a repayment plan, and that repayment plan could be up to 24 or in some instances 36 months. The bill should not make life difficult for specialist homelessness service providers in the instance that tenants seek their assistance, and at the same time knowing that the maximum market rent will be charged. Now, we understand that will be capped at $1,400, but the reality of property prices in Sydney is that in most locations that maximum will become the payment, and everyone will be paying that amount. So it's important in that instance that there be a proper repayment plan. Turning to Schedule 1 of the bill, it refers to amending the Residential Tenancies Act 2010 with respect to incorporating provisions relating to the rental bonds scheme. Specifically, it states, and I quote, proposed section 156D enables the corporation and the Aboriginal Housing Organisation to require a tenant to pay a rental bond at any time after the agreement has commenced, unquote. Adding proposed section 156D is a retrospective change that will allow the New South Wales Land and Housing Corporation, which is the land-owning entity of the state government for social housing, and the Aboriginal Housing Office to require existing tenants who have intentionally or negligently caused more than $500 worth of property damage to pay a rental bond at any time prior to the end of their tenancy agreement. In addition, proposed section 156C enables landlords to give a termination notice for non-payment of a bond once it is more than 14 days overdue. Now, we understand that the termination notice given for non-payment of the rental bond scheme if the rental bond is 14 days overdue makes clear that on paying the bond or on agreeing to a repayment plan, tenants will not be required to vacate the premises, and that's an important qualification. A collective of stakeholders, including the Tenants Union, Homelessness New South Wales, Shelter New South Wales, People with Disability Australia, New South Wales Council of Social Services and the Combined Pensioners and Superannuants Association of New South Wales, have issued a statement highlighting a range of concerns relating to the rental bonds scheme. These will be placed on the record. Homelessness New South Wales Chief Executive Officer Catherine McKernan states, and I quote, "This is not only creating further barriers for people in accessing housing, but it will also mean that homelessness services will potentially have to use brokerage funding to cover it. The government may end up paying for these costs itself." Leo Pattinson-Ross, Senior Policy Officer of the Tenants Union of New South Wales, has stated, I quote, "The time and money the department will spend on administering the system would be better spent on providing new housing, completing the maintenance backlog, or providing more assistance to homeless people," unquote. Dean Price, Senior Policy Officer at People with Disability Australia, has identified, and I quote, "People with a disability already face huge barriers in finding an affordable and accessible place to live in. Public housing is one place where many people with a disability find a home, and introducing bonds will make this much more difficult to access," unquote. Karen Walsh, Executive Officer of Shelter New South Wales, has stated, and I quote, "The policy will have a serious impact on those people already doing it tough. There is not adequate protection for people with dementia and other mental health issues. The behaviour of people from outside the household or decades-old damage caused by former occupants, which is only recently discovered," unquote. Now, just pausing there, that issue of making sure that when we're holding tenants to account in the way proposed in this legislation, that an appropriate benchmark be set is the subject of Labor's second amendment. That is, there does need to be a condition report done at a point in time so that when we're holding a particular tenant to account, there is a baseline against which to measure their custodianship of the property. If we're going to sling people out of their homes for doing damage, whether recklessly or intentionally, we've got to make sure that they are the ones who are responsible for that damage. It's not just fair and just. I think it's the obligation on government to do that properly, and on us as legislators and policymakers to ensure that that proper step is taken. Those statements I've just referred to, or that collective statement, was issued on the 21st of June, just a couple of days after the budget, and on the same day that the Minister in the other place second read the speech in relation to this legislation. So the Minister obviously wasn't available, didn't have that statement to hand at the time. It would be useful if the government in this debate, or at a subsequent point in time, was able to respond to the concerns raised in that collective statement. We are mindful that the stakeholders in that statement have an enormous number of members, and that they have access to a large number of persons who are vulnerable and who would have concerns about the scheme proposed in the legislation and might be confused about what it means for them and how it will work. The absence of guidelines until today, we think, would also raise concerns with people when we're making a decision on retrospective laws, as we're asked to do so in this case. It would have been good had the guidelines been available earlier, but I do ask the government to promulgate them to affected parties and stakeholder groups as quickly as may be, to consult with them about the contents of the guidelines and to make any necessary adjustments in line with feedback from those stakeholder groups. Again, if we're going to do this, let's do this properly and let's address unintended consequences to make sure that in seeking to do some good, we don't incidentally make life harder for those who are already doing it tough. Earlier in the year, the department had discussions with various stakeholders. One of the comments that the Minister made in her second reading, according to the Minister in her second reading speech, she did say, and I quote her, "Safeguards will be put in place to ensure the needs of vulnerable clients are taken into account, as well as any extenuating circumstances faced by social housing tenants. For example, no rental bond will be required of a victim of domestic and family violence where the damage is caused by a perpetrator of domestic violence," unquote. We appreciate and endorse those comments made by the Minister, and we also understand that stakeholders would be able to provide a variety of examples, whether we're dealing with domestic violence or persons with disabilities, or indeed elderly tenants suffering from forms of dementia or Alzheimer's, and both members in this chamber and of course more particularly lower house members who have direct responsibility for constituents would be able to also give many examples of potentially examples where damage has been done but it has not been willful or indeed even negligent. It's simply been because of the circumstances being faced by the tenant. So I imagine the government's response would be that there'll be some discretion in the legislation, but I draw honourable members' attention to page 3 of the bill and proposed 154 capital F capital A, termination by tribunal and certain cases of tenant fraud. Subsection 5 really alleviates the tribunal from having to make a termination order if the tenant satisfies the tribunal there are exceptional circumstances that justify the order not being made. Exceptional circumstances has been judicially interpreted and limited to really not entirely unique circumstances, but a very narrow range of circumstances. And I think it's the view of the opposition that that safety valve in the legislation is simply not sufficiently robust or broad enough to deal with a variety of unintended circumstances, and that is the substance of Opposition Amendment number 1, particularly proposed 5A. 5B really replicates what is already in the legislation. So I'd ask honourable members to give earnest consideration to that amendment. In 2015, amendments were passed in the Residential Tenancies and Housing Legislation Amendment, Public Housing Antisocial Behaviour Act. Section 154D allowed for hardship considerations. Similar amendments need to be made with respect to this legislation, as I've indicated. Because we want to make sure that in improving the situation in social housing, we don't further escalate rates of homelessness in this state. Some of the responses from the Homelessness New South Wales survey are quite instructive, and the Shadow Minister in the other place read from them to some degree, quite extensively. But I'll just quote a couple of paragraphs that I think are particularly pertinent. One is, and I quote, there are so many set-up costs when you get into housing. You go from nothing and you need to get furniture, food and fridges. All of these are a massive expense, and to put a bond on top is going to be too much. The government forgetting that people are struggling. And finally, I quote, if people are unable to re-access social housing, then there are often no options left for them. Generally, they are not a preferred candidate in an overcrowded private rental market, and that often they end in unsafe situations whilst waiting to re-access housing, unquote. Homelessness New South Wales has also raised concerns regarding retrospective penalties for damage that was present prior to the bill being introduced, as well as it creating a disincentive for reporting any property damage that may occur. Homelessness New South Wales has also raised concerns about fairness and due process in respect to retrospectivity, applying a bond for damage made before the policy was introduced. It stated, and I quote, applying the bond for existing tenants will also create disincentives for current tenants in terms of reporting property damage. This may lead to properties being left in poor conditions for lengthy periods of time, unquote. This concern also requires an amendment, which I've outlined, to be made to ensure that a condition report is completed for the property in question so that any existing damage is rectified. If landlords are to fulfil their roles and seek rental bonds, it's important they understand they have a duty to ensure the property is up to scratch before instigating a rental bond scheme. We do not want to set up a system that in any way, shape or form prevents tenants from making requests for maintenance or repairs for fear that they might be held responsible for the damage, especially in instances of normal wear and tear. Provision should be inserted in the legislation, or the guidelines, or perhaps both, so that tenants, particularly elderly tenants who wish to make simple repairs, are not prevented from coming forward because they're fearful to announce they require repairs to their property. And this is the case because the legislation is retrospective. Let's assume a tenant's living in a property. Let's assume that damage has already been done, not their fault. Once this legislation comes into force and effect, the risk is they'll be held accountable for that damage or have to explain it. For those reasons, fearful that they may have to foot the bill or pay a bond, they may not come forward. That damage may be discovered at some future point in time. They're going to be held to account. They're going to try and give some explanation that either it was like that when they came into the property, or that some other third party or DV perpetrator was responsible, and who knows where the decision maker will come down. So we think that condition report is an important social justice measure, which is, of course is now amendment number 2. Reports put the damages figure that this legislation is dealing with at $16 million. I'd like the government to clarify that. There's, of course, an extensive social housing waiting list. Sometimes the number is 55,000, sometimes 60,000. But what we know is that more than 100,000 people have applied for and are waiting for social housing. And many more people are yet to be placed on the waiting list, potentially needing housing. The minimum average wait for a 2-bedroom or 3-bedroom property in metropolitan Sydney, the Central Coast, Newcastle, the Illawarra or the North Coast is 10 years. Considerable concern has been expressed about some of the property sell-offs that have taken place over the years and the high number of vacant properties in the state of New South Wales. In 2011, there were 99 properties that were vacant. There are now 1,500 properties, if not more. And we would be glad to hear from the government if the number of vacant properties has changed, but the last time the opposition checked it was 1,500. The government should look to how it can amend the bill to ensure that all provisions under Schedule 1 square brackets 2 relating to rental bonds in corporation or Aboriginal housing office tenancy agreements apply to premises that have a property condition inspection subsequent to the commencement of the bill. Consideration should also be given to amendments that allow for a formal means of discretion in collecting bonds with regard to undue hardship such as domestic violence, disability, mental health and elderly tenants. It's important that specific amendments be moved, and I propose to do so, but I'd welcome the government either adopting our amendments or moving their own in this respect. Consideration must also be given to a review of the bill so that we can be confident that there's an opportunity in the near future to avoid any issues surrounding homelessness or any unintended consequences of the legislation that have exacerbated homelessness or have made it difficult for tenants to have repairs undertaken for fear of reprisals or having a bond placed on them. We need to be confident that the agency does not have any further administrative costs. We understand the budget was handed down a few days before the Minister introduced the bill, and we're not sure whether the administrative costs would place some burden on the department in respect to the repayment plans, overseeing the bond scheme itself, undertaking property condition reports and ensuring everything runs smoothly. I imagine there'll be some additional costs. If they were included in the budget, we'd also like to hear that, and we're keen to hear from the government what those foreshadowed costs would be over the next 12 months. We note that the funding in the 2018-19 budget for maintenance was significantly reduced by $34 million in the from the 17-18 budget. We also note that specialist homelessness services were underfunded and under immense pressure. In 16-17, they provided assistance to more than 74,000 clients, despite being contracted to only deliver services to 58,000 clients that year. Schedule 1 of the bill inserts a new 154F that requires the New South Wales Civil and Administrative Tribunal to terminate a residential tenancy agreement where the tenant has been found guilty of a fraud offence under Section 69 of the Housing Act 2001. Currently, there is not a direct method of eviction for this conviction. Instead, tenants are generally convicted for failure to pay the debt created by the actions to which the fraud relates. There have been examples where the Department of Family and Community Services has also used the Section 85 no grounds notice. I appreciate the requirement for the legislative change. Examples in the media of late have been alarming. The bill as written allows for these evictions to occur in very minor instances where the failure to disclose was unintentional or where a third party has caused the alleged fraud. It's been explained that facts will only proceed to conviction in more serious or willful cases of fraud. Many stakeholders received that briefing from the department and were advised that only in instances of serious or willful cases of fraud would facts proceed to evict tenants with those particular convictions. But that's not how the bill is written, and it's imperative that an amendment be moved to ensure that facts only instigates those terminations in relation to cases of fraud. Mandating termination except in cases of exceptional circumstances removes the ability of the tribunal to consider all relevant circumstances before terminating a tenancy and may, in some circumstances, result in unjust outcomes. For example, in cases where a domestic violence or relative abuse can be demonstrated to have been a factor in the circumstances in which the fraud occurred. We know that takes place. There are many examples of elder abuse that could potentially result in a tenant being convicted of fraud. In those instances, there needs to be some ability for the tribunal to allow for some type of discretion. I'm concerned that the bill, as it currently stands, discretion will not be permitted to the tribunal. It's imperative that there be an amendment that does that, and we propose it as one of our three. An alternative and more appropriate mechanism would be for termination on the basis of conviction of fraud to be added to Section 154D of the Residential Tenancies Act. That would still allow appropriate discretionary powers in instances where undue hardship or particular circumstances should be considered, namely those provided for in the current 154DB. Schedule 2 provides a raft of changes to the Housing Act 2001 and extends a provision that enables the Secretary of Facts to terminate the lease of a public housing tenant who is a registrable person within the meaning of the Child Protection Offenders Registration Act 2000. Other amendments about which the opposition has no concern, including to 58B, where residential tenancy agreements may be terminated by a community housing provider, as defined by Section 58A on the recommendation of the Commissioner of Police. Again, in instances of registrable persons, where should police believe the tenant poses a risk or is a risk to themselves, and with the approval of the Secretary of Facts in the same way that the Facts Secretary is able to terminate a residential tenancy agreement of a public housing tenant who is a registrable person. Obviously, the community housing providers agree with this particular change, and so does the opposition. Alternative housing will still be made available, which is part of the proposed amendments. which will make it simpler and less burdensome on community housing providers in instances where they need to move tenants. The bill proposes amendments to 69B, 69C, 73 and 74 2A that will empower the Facts Secretary for the purposes of accessing information and documents for the purposes of investigating or preventing fraud and recovery of payments obtained fraudulently. We do not have any concerns relating to those changes. The opposition do not oppose the bill. We have raised suggestions and concerns on behalf of stakeholders because I believe the collective statement issued immediately after the Minister delivered her second reading speech and some of those concerns do need to be taken into account. Housing is a difficult area and a great deal of burden is placed on the many stakeholders that work hand in hand with housing and community housing providers. We do not want cost shifting with the result that tenants turn up at the door of specialist homelessness service providers seeking the use of their brokerage funding. That would only exacerbate problems in the sector and the rate of homelessness. We should be targeting those who deliberately and willfully damage public property and those who fraudulently obtain a benefit at the expense of good tenants and those on the waiting list who are being deprived of the opportunity of a home, which I'm sure they would care for. So it's important that we get this legislation right, and it's important that we get the driver the ministerial guidelines right, and in that spirit of cooperation we propose our 3 sensible and balanced amendments and urge all honourable members to join with us to improve the legislation.
Senator Noble.
Mr Assistant President, to suit the